Good afternoon. So, what a day it's been, day 23. The discussion went from human rights to gender sensitivity, but lots of important things were also tackled this afternoon. And joining us to look at the highlights of the day is Rappler Editor at Large Marites Vitog. So, ma'am, lots of other issues taken up, but of course, crucial ones. Like, what to you were the top issues for this afternoon?
I think something to look forward to is whether Justice Maria Lourdes Sereno will agree to testify in this trial. That's going to be significant because of the February 14 resolution of the Supreme Court that the justices are not allowed to testify. I mean, they will not be subjected to any subpoena. It will be voluntary on their part. So let's see. Next week, that's something to look forward to. The other thing that's interesting today, apart from what Senator Enriquez said about the nature of this impeachment trial, that it's not really a criminal trial, that there's sort of more flexible weighing of evidence. What I found interesting today is it gave us an education on the workings of the court.
Yes.
We saw how difficult it was for Secretary De Lima to say she had personal knowledge. Because in the first place, only the justices are allowed in en banc meetings. There is no staff or clerk, as Senator Lacson said. Why don't you subpoena a clerk or no such thing in the en banc meetings? It's just the 15 justices. And it's true, the internal rules say that the Chief Justice takes down notes. And his notes are the ones that are given to the clerk of court or to the public information officer who makes the announcement. So we're seeing a really very closed and secretive institution, and this impeachment trial is breaking it open and giving us a ringside view, actually.
And it's also interesting that, as you said, some of the senators seem to be knowing these pieces of information for the first time. Like Senator Lacson didn't know that, for example, in an en banc, it's just the justices. But speaking of the information that Secretary De Lima got, the personal knowledge, as you said, it was interesting because this afternoon she cited executive privilege when asked about whether or not she has sources other than the dissenting opinion. So, what do you make of that statement?
It's very interesting that she sort of admitted that there was earlier information that she received, whether from a justice himself or herself, or through a third party. We'll never know, or we may know eventually. But that means that there is communication between the executive and the Supreme and the judiciary. Well, it's a very Filipino culture wherein my guess is it wasn't a direct communication because it's very sensitive. The justices don't talk directly to the executive. It will show a lack of independence. It will show a too cozy relationship. Yes. They should really have distance. That's why justices don't even go to Malacanang Palace to attend functions, except in, I think, very rare occasions, no, like diplomatic with the vin d'honneur, that's once a year. But other than that, or maybe there are justices who take their oaths of office, so other justices go to the palace. But they have to be very sensitive about being seen or being known or being perceived as having close contacts with the executive.
So, putting the testimony of Secretary De Lima to perspective, what do you think this means for Article 7, considering that the bulk of what she said was based on the dissenting opinion of Justice Sereno? How do you think what the prosecutors didn't seem to achieve through a subpoena of an actual justice, they tried to get her to say it? But what do you think, was there any additional, kumbaga, was there an added value to her being here? That because we saw the senators were very eager to ask her opinions, for example, even if she's a witness, like an ordinary witness would not be asked about her interpretations of certain procedures or the law? What do you think is the value of her testimony?
I think she just set the tone. She sort of narrated, as Enrile said, they would accept her narration of events because she was a party to the case when she did not follow, she defied the TRO. So she set the tone, sort of a curtain raiser, but we really need it would really help us understand and of course make it more clear and emphatic if the Justice Sereno herself testifies, but that again, that's still up in the air. This is going to be a first, if
Yes.
ever. And if you read Justice Velasco's opinion on the TRO, he did not dispute Justice Sereno's account, her timetable. What he said was he questioned Justice Sereno's disclosure of such of what happened in the court. He said that there should be confidentiality because otherwise they will be. I think Justice Abad said there will be a chilling effect on the other justices. So, but they did not. Velasco nor Abad did not say that Sereno lied. So that's very valuable. And it would also be helpful, I think, if they call Justice Velasco because he was the one who wrote the resolution which was altered by the Chief Justice.
Senator Trillanes moved to ask for written interrogatories. Of course, it's not clear to us what exactly he means, but in case it's something like the Senate sending questions to Justice Sereno, do you think that would help the case in any way, or would she in effect be repeating what she already said in her dissenting opinion?
Yeah, I don't think written answers to questions would not be as helpful or dramatic. Remember that people want to hear, people want to see, and if it's just written questions, we could easily read her dissent. So I think the value is really for her to be physically here and take the witness stand. It's going to be a challenge for the prosecution to shape up and ask the good questions, the right questions, so that they will elicit as much information as they want.
If in case.
If in case.
So going back earlier today, of course, there was that crucial statement of Senator Enrile that this is not a criminal trial, that this is only akin to a trial, and later on in the day he was citing U.S. authors like Charles Black, and he said if you read what those authors said, they said that the quantum of evidence required is an overwhelming preponderance of evidence, or even clear and convincing evidence is actually sufficient, is enough, what he said. So what do you think this seeming change of the Senate President, what does this mean moving forward? Does that amount to ruling? Is that a new rule of the court? What do you think are the effects of that?
Yeah, I was surprised by the epiphany of Senate President Enrile. It sort of lightened the atmosphere today. It really made us heave a sigh of sort of relief that it's really what people have been saying. It's an administrative matter. I mean, to put it in the extreme, Enrile said there is no imprisonment, no forfeiture. The only punishment is removal from office. So it really again sent an important message to the public, to the defense, to the prosecution. Maybe I'm guessing that part of this lightening up or being seen to be flexible and liberal, more liberal, is the public opinion.
Okay.
If you I just gauged by some of the opinions on the PAL ruling when he said that the PAL executive could not testify. There was negative public opinion on that. It's hard to measure, but I've just been reading editorials and some opinion columns and some in the social media. And the Inquirer had a very good editorial, and the Inquirer said that let's have wisdom. Let's have wisdom, not legalities. So I think it put the case quite well. I'm just speculating that maybe public opinion has something to do with his lightening up.
Okay, so moving to next week, it's week 7, more than a month of this, and we're hearing talk that the prosecution may wrap up their entire case for this trial. At this point, we've done Article 2, we've done, well, very little of Article 3, and now Article 7. Do you think what has been established so far, is it substantial? Is it something that stands?
Yeah, I think Article 2 is their strongest so far, because that is really very clear that so many assets and cash were undeclared. And it's now up to the defense to explain, or maybe defend, rather, explain how this all came to be. So I think it's very, very clear in my mind and in other people's minds that Article 2 was presented in a very convincing manner. But we still have to wait for the Senate's decision on whether to include the bank accounts.
As evidence.
But considering what happened today, there may be some, more liberality. It might be included. After all, the PS Bank president testified and confirmed the accounts. You know what? Looking back, it's just that the prosecution should have insisted on pursuing the part of Article 3, which shows that the Chief Justice reimbursed his personal expenses to the office, meaning he used public funds for personal gain, for personal uses. But they did not pursue it because of the Supreme Court order saying that the employees could no longer testify. But that only referred to adjudication or deliberations on cases, not on the financials or administrative matters. So looking back, that would have added to a better picture of the Chief Justice. But anyway, it's a lost opportunity.
Okay, so anyway, next week proves to be exciting. We'll see if this will finally end. What are your thoughts on that? Do you think it's enough? Like, what happens to the other articles, for example?
Yeah, I think the prosecution, that the thinking now really is to end it with Article 7, and no need to, may I quote Senator Angara, no need to prolong the agony of this nation. If you have presented your case, in the case of President Bill Clinton, just one case, just one item in the impeachment complaint. So why prolong it if they're convinced that they have presented clear evidence on Article 2?
Okay, very well said, Ma'am Marites Bitog. Let's see next week if the agony of the nation, so to speak, will still be prolonged. We now bring you the press conferences of the prosecution and defense teams.